Annex, are you with us?
Yes, Your Honor.
Very well. Good morning. Thank you. Thank you for being here with us. It is 8 a.m. 7/2/2021. Tony Orozco. At this time, court calls cause numbers 2019-78 and 3244. The state of Texas versus Tony Orozco. Announcement of council, please.
Josh Avila for the state, Your Honor. State ready?
Robin Norris for Mr. Orozco. I'm ready, Your Honor.
Okay. Mr. Orozco, good morning. Mr. Orozco, do you recognize your attorney, Mr. Norris?
Yes, I do.
And Mr. Norris, do you recognize your client as a defendant in this case?
Yes, I do, Your Honor.
Very well. Let the record reflect that both have identified each other. Go ahead, Mr. Norris. You may begin. This is a bond hearing.
Well, let me first start by saying, as the court knows, we've had some off-the-record discussions with me and opposing counsel in the court about this issue, which is a little more complicated than my ordinary bond issues. And as the court knows, I take a different view of things somewhat than others, and then the court has, both in this case and in other cases. Just to recap, back on August the 25th in 2020, Mr. Orozco was in court with his prior defense attorney, who has since withdrawn, in fact, appears to have withdrawn as a result of Mr. Orozco's behavior in court at the time, at which time he was disrespectful to the court, and the court sentenced him to first 3 and then later 6 days in jail for contempt. Mr. Orozco did not surrender himself and was at large until May, I think, of this year, when he was arrested on a subsequent offense, and the outstanding capias for his arrest as a result of the court's apparent contempt order or subsequent revocation of his PR bond was executed at the time of his rearrest.
What was the new offense, Mr. Norris?
The new offense was a possession of controlled substance. It has still not been indicted, I think. I may be wrong. I haven't checked recently.
It hasn't.
It was a P file still.
Okay.
The day after the court held him to be in contempt, the very next day, a notice of violation of PR bond conditions was filed with the court and an affidavit. That affidavit assigned as a violation of his PR bond conditions only that he had failed to report on the 25th, the very day he was in court and misbehaving. Since that time, I don't see any other violation notices or affidavits filed with the court.
Doesn't the affidavit state that he would report a day or two late? Because that's what I recall was the reason for the revocation of the PR bond.
Yeah.
The PR bond summary stated that while he reported, he always consistently reported a day or two late. The affidavit doesn't state that, Mr. Norris?
No, it does not. And I believe the court will recall that that matter came up later during our email thread conversation, in which his PR bond officer did mention that later. That's never been cited by her or anyone else at the PR bond office as a basis to seek a revocation of his PR bond.
Sam, can you send me the PR bond affidavit right now, please? Email it to me. Because I recall that was the reason why I revoked his PR bond.
Yes, I think that must be a mistake, Your Honor. I'm looking at the personal bond violation affidavit filed on August the 26th of 2020. But I want to say I don't consider that in any case to be the kind of violation of his PR bond, considering his otherwise, perfect compliance with drug testing, to be a sufficient reason for a revocation of his bond. Many of my clients have reported to me that they have difficulty reporting. Sometimes they just forget. Sometimes they're working. Sometimes they're busy. It's not really an excuse, but it also isn't really an indication of a likely failure to appear in court as required, which is what I want to emphasize. I know the court and I have differences of opinion about this, and these are honest differences, I recognize, but I always feel as though I'm obliged to remind the court that the purpose of a bail bond is only to secure the appearance of the defendant at trial. The court is authorized to consider the safety of the community, but only insofar as it may be relevant to the question whether the defendant is likely or not to appear at trial and whether the bond is sufficient to secure his appearance. Mr. Orozco is substantially in compliance, even if he was a day late making a report now and then. And so I accept the fact that that might have been the basis for the PR bond office to file a violation affidavit, but they never did. And they certainly didn't on August the 25th. So I mention that only because my purpose in my motion for a bond hearing was to have the court simply to reinstate his bond and to treat his disrespect to the court on that date as being a matter to be addressed through the court's contempt power, not through the revocation of his bond. I can tell the court a few things about Mr. Orozco that would help, I think, to reassure that he is not a flight risk, that he will be in court as required, as he always has been in the past. He's never posed a flight risk. He has been effectively a lifelong resident of El Paso, graduated from Burgess High School, has been employed continuously for 15 years until his most recent arrest as a bartender, expects that he can be re-employed as a bartender when he is again released. He has strong family support and a permanent residence here. And as I say, is no kind of a flight risk and has really, I believe, not been in non-compliance with the conditions of his personal bond. It's certainly not in any non-compliance that would remotely suggest that he wouldn't appear in court as required. The court need not worry about that.
The affidavit that you're referring to that I signed, that were made the basis of the warrant. I mean, the affidavit was dated August 25th. It says that he was scheduled to report on 8/25/2020.
Yes, Your Honor.
Did not report.
He was in court. That was the date the court held him in contempt.
But he has to, just because he's in court doesn't mean.
I understand, Your Honor, and technically that could be regarded as non-compliance with the PR bond. And I've acknowledged also that late reporting is also technically a violation of it. But I'm urging the court to see that that's not the kind of violation that suggests that there is any concern about his failure to appear at any time.
Okay.
He's not a flight risk, and he's not.
Well, he was scheduled to. He was asked to report on 8/25/2020, and he did not report. Is that correct?
Apparently, he did not, but he was in court on that date. That's the date he was held in contempt.
I heard you. I want to ask Ms. Williams. Ms. Williams, according to your notes, and was he supposed to report on 8/25/2020, and did he report?
Was supposed to report August 25th and he did not. Even on August 24th, Stephanie Flores, his officer, called him to remind him of court and asked him to call her back. He did not. And even on the 26th, the day after, Stephanie made contact with him, but because she called him, not because he reported on his own. She reached out to him because of what had happened in court, making sure he was aware about the commitment that the court had implemented.
Okay. So those are technically violations.
Yes, of course they are, Your Honor. My point is only that they are not violations of such a nature as would justify the revocation of the bond of somebody who is otherwise fully in compliance with his conditions and presents no flight risk whatsoever. bearing in mind again that the purpose of a bail bond is only to secure the defendant's appearance in court as required, not to micromanage his life. The reporting requirement is designed to make sure that the court knows where he is on a continuous basis and can be assured that he will appear as required. And I don't believe that the court would be justified in a conclusion that his late reporting or failure to report on that particular day is any rational indication of a danger that Mr. Orozco would not appear in court as required.
Okay, that's your perspective.
Yes,
I
Your
respect
Honor.
that. I don't agree with it, but that's your perspective.
I understand, as I stated, we have a difference of opinion about these things, but it's an
Okay.
honest difference. I accept that. I'm just asking a little latitude for Mr. Orozco. He's been in jail now for, in a few days, it will have been a couple of months. I think he's been fairly chastened for his misbehavior, something which I don't quarrel with at all, the court's action in that regard, as the court knows. And I would beg the court's indulgence to reinstate his PR bond, give him another chance. I feel certain that Mr. Orozco will be far more fastidious in reporting precisely on the days he's required to without delay.
As you have heard in the previous bond hearing, my policy, once I give them a one free pass out, they violate, I impose a minimal surety, right? A minimal surety. You cannot break policy or procedure for you or for Mr. Orozco.
Well, a minimal surety in the alternative is what I would look for.
Right.
Currently, the court has his bond set at 100,000.
Right.
That's
Mr.
a bit
Avila,
above minimal.
what's your perspective in this case, Mr. Avila?
Judge, so as Mr. Norris indicated, we had an email chain, right?
No.
I wasn't part.
It wasn't an email chain. It was an email novel. Back and forth, back and forth, back and forth.
Judge, I wasn't part of your court back in August 25th when the incident happened for him to be getting a jail commitment, but it is on YouTube, right? And we emailed back and forth as to the August 25th hearing, right? It was around the minute 17 where he appeared and he gave him a jail commitment and he said he wasn't going to turn himself in, right, Judge? However, another context that needs to be given in this case, Judge, is that, you know, the court didn't sign the PR bond revocation warrant until September the 9th, right? So he was given about 2 weeks to turn himself in. And to me, what that tells me, and Ms. Williams can tell me otherwise, is that he just failed to report. We lost him, right? And I disagree with Mr. Norris on, yes, sure, the bonds are partially set to ensure his presence, right? But also to ensure that he's reporting and to ensure that he doesn't abscond, which is what happened in this case, right, Judge?
Well,
He absconded since September.
Don't
Yeah.
interrupt him. He didn't interrupt you.
He absconded from September of 2020 all the way up till May when he got arrested, Judge. Now, Mr. Norris did make a statement that he was apparently reporting, but he was constantly being told to turn himself in, which he didn't. Now, I do want Ms. Williams, if Ms. Williams has any notes on that, I would love to hear as to whether or not he was still reporting, but he hadn't turned himself in, or if we just completely lost him.
Ms. Williams?
Yes, Your Honor, I do not see any notes to reflect that Mr. Orozco reported. After the last day that we had contact with him, or at least attempted contact, was May 11th. After that, I don't have any notes.
May 11th of what?
Of 2021, I apologize.
No, but Mr. Avila's asking, after the bench warrant September that I signed in 2020, did he report to the PR bond office?
It looks like he was reporting in September, October, no. Yes, December. So he did continue reporting, yes.
He did continue to report in spite of the fact of the bench warrant being.
So he was reporting every month?
Ms. Williams?
Yes, Your Honor, I see here he did report multiple times. Let me see. I have September 16th. September 24th, October 2nd, October 14th, November 4th, November 20th, December 10th. Yes.
So he reported up until his arrest, May or June, or when did he get arrested?
May.
Okay. So he reported every month until May, Miss Williams, correct?
Correct, Judge.
Okay. There's your answer, Mr.
That and that's the misconception we get, right, Judge? We just see a warrant and we don't see it executed, and we assume that people don't report. So in all honesty, Judge, it doesn't seem like Mr. Orozco has a problem with reporting, right? His problem is the attitude problem. And Judge, he recently picked up a new case, and both of his possession charges are meth type offenses, Judge. So I do think he might have a meth use problem. In fact, in the new case, I read the affidavit a long time ago that he had those glass pipes used for smoking methamphetamine. So, Judge, I don't know if you want to address that on any bond that you're going to set.
Yeah, let's see if he wants my help. What I'm thinking of doing is putting in a $2,500 surety. That's a minimal amount, Mr. Norris.
I agree.
$2,500 surety, and I'll reinstate the PR component. Mr. Orozco, I hope you have a different and a better attitude towards me, sir, because I want to try to help you with your meth addiction.
Yes, ma'am.
Do you want my help with the meth addiction, or you don't want my help? I'll
Yes, ma'am. I will take your help.
I'm sorry, sir.
I said I will take your help.
Good. Okay. What do you think you need, sir? First of all, I have to commend you. I have to commend you, sir, because you continue to report and continue to report and continue to report. That spoke volumes to me, okay?
Thank you.
Well, that's good, okay? So what do you need? Do you need, can I put you maybe la liviane outpatient?
That'll be fine. I'll take that.
I don't want to keep you under a lockdown facility, but let's try a liviane outpatient. Mr. Orozco, I'm going to tell you, sir, if that doesn't help you, let me know. Tell your attorney. I don't like this program. It's not helping me, whatever, because I want to try to help you, put you in a place where substantively it will help you, okay?
Okay, thank you.
Okay, sir. So the only other term that we're going to add, because it was my PR bond, Mr. Castañeda, right?
No, Judge. So
Oh,
in the case ending in 6278, it was a PR bond, not your bond. And then on the 3244, I'm looking at it as having been a 2,500 cash surety, but it is showing in the system that has been revoked since June 16th.
Revoke the cash surety?
Correct.
They filed the affidavit of incarceration,
Let me just double check, Judge.
or they surrendered it. So I have to put a bond on both cases.
I don't see an affidavit file, Judge, but I went to the bond tab and it's showing as being revoked.
Now,
Well, how
this
do
is
you
on
know?
which case?
The 3244.
And which is that? Let's see, I don't have that in front of me.
That's the possession. How did that get revoked? What did we do to revoke it?
Probably because of his rearrest, again, I would think, but
Judge,
No, but this-
if we can make it easier, I'll agree to appear bond on the 344 or on the 3244. It's
Judge, and I don't know if this is an issue. I do see a pending detainer,
yes, I saw that, Sam,
and
and it's for JP court, right?
yeah, I don't know what that means.
Yeah. So I saw there was a warrant, Judge, for failure to pay a fine on a Class C misdemeanor. It was an operating vehicle without registration, I think, and the JP court issued a warrant. So while we might have an agreement on the bond and he might post the bond,
Not gonna
he might be taken to JP court to address the fine that he owes.
Well, he's not going to be able to get out of court until you clear that up, Mr. Norris, okay?
yeah, so this is traffic warrant, I guess.
Right.
Yes, I have a case number, Mr. Norris, if you're interested.
Well, I'm interested.
He has to be.
It's-
He has to get his client out of jail.
It's let me see. So I'm pretty sure this is the way the cases are set up there, but it's 6.119 dash 00089 dash TR.
Wow, that's a weird number. What court, what JP court is that out of?
It's precinct 6, place 1. That's what it says.
P6, place 1.
Okay.
Yeah, when I speak with Mr. Orozco about it, he may have some more information for me that will enable me to help resolve that.
Right, okay, sir. So then what we're gonna do in cause number 3244 pursuant to Mr. Avila's agreement, I'm gonna put him on a full 10,000 PR bond. On 6278, I'm gonna put him on a 2,500 surety, 10,000 PR component. My PR bond imposed in both cases, no bars, no drugs, no alcohol, no arrests, no offenses against the state of Texas or any other state. You cannot leave El Paso County unless and until you have my permission. Mr. Orozco, you're gonna report 1 time a month to your PR bond officer. You're gonna report 2 times monthly with 24 hours notice. I'm gonna try to give you a little bit more supervision on the UAs. These are for UAs, Mr. Orozco. So you could be called at any given day, any given moment, any given week to get a UA. So maybe that'll keep you away from drugs.
Your Honor.
Then there's gonna be a 9 to 6 a.m. curfew. He's gonna go to Aliviane for substance abuse. And again, Mr. Orozco, if that doesn't help you, let me know. Your attorney said something about a bar or bartending.
Yes, Your Honor.
I don't want you to do that, Mr. Orozco. You know what happens in bars? Sex and drugs.
Yeah, I know. I've been working for the last 6 years. That's, I'm sorry.
The problem. I think we need to steer you away from a bar.
Well, may I just say something, Your Honor? It may very well be the case that Mr. Orozco can find employment elsewhere, and certainly I would encourage him to do that. But my information from him is that he has a 15-year career as a bartender, and if he has difficulty finding other employment, I might want to ask the court's permission to have him work, no bars except for his employment.
No, that's where they hang out once they get off of work. They do drugs, they drink. No, Mr. Orozco, let's try to help you. When I saw you in August, you were working at a Valero, weren't you?
Yes, because of the whole pandemic and the bar was closed. We have to shut down.
Okay. Mr. Orozco, you're a bright, employable individual. You really are. I can see that. I think you're going to be an asset with whichever. I have a probationer that is doing wonderful, just going up the ladders quickly with Cracker Barrel.
Yes.
With Cracker Barrel, try Cracker Barrel, go back to Valero. I want to keep you out of the bars.
Okay.
That's bad shit happens.
Understand.
Okay? So bear with me. Not that I'm never ever going to let you go back, but for right now, once we get this addiction under control and all of that, okay, I'm not doing it to punish you. I'm doing it to help you.
Yes, ma'am. Understand.
Okay, sir. Okay. What else? Did I finish with the PR bond? My PR bond, Mr. Sam?
I don't know if there's, I see that there's a burglary, Judge. I don't know if is there no contact?
Was it a girlfriend or something?
It was a friend, I believe.
Yes.
Can I
It was a
put no
friend.
contact with that friend, Mr. Orozco, or do you still deal with that friend?
No, I haven't. I haven't talked to him or dealt with him.
Are you okay if I put no contact with that complaining witness?
Yes, that's fine. No
Okay,
problem.
no contact with whatever the complaining witness's name is in that case?
Christopher Chavez.
Okay. What else? Anything else, Mr. Sam, Mr. Josh?
I believe that's it, Judge.
Great.
No,
thank
Your
you.
Honor.
Okay.
Judge,
Okay,
before
Mr.
I'm sorry.
What?
On the P file case, are we gonna leave that alone?
Yeah, we're gonna leave
Okay.
it alone. Mr. Orozco, where are you living? I don't know if we need to put this in, but where are you living, sir?
I live on the northeast.
Are you living with somebody or by yourself?
No, I live by myself, but I have a roommate too.
Okay. That roommate is not bad news?
Oh, no, he's a truck driver, so he's never there.
Okay, okay, so you're good with that. We're good with that. I don't
You
like the
okay?
Northeast. The
You
Northeast has,
with that, Judge?
the Northeast has a lot of drugs. I don't think so. I don't need to report. I don't have a problem with Mr. Orozco not reporting. He even reported even with a bench warrant. So I don't want to keep track of him and the address and all of that.
Thank you.
Okay, Mr. Orozco, we started off on the wrong foot. Let's forget about it. Like I tell my daughter when she was 5 years old, we're starting from scratch. Okay, we're starting from scratch.
Appreciate it. Thank you very much.
Thank you. What
Judge, if
else?
I may, we don't have future hearings on this. What would you like me to set it for?
Maybe a settlement conference. Can we work something out right now? We have 10 minutes. Can you give him a plea offer, Mr. Avila, or you're not?
Josh did just send me a chat on that, and I need to talk with him about it a little bit, and particularly because we're trying to address all of the charges. So I don't think we can really resolve anything right now. But Josh did reach out to me with a suggestion, and we're going to talk about it.
Okay, Mr. Norris, can we set it up for a settlement conference in about 3 weeks?
Yeah, I'm going to be
That's right.
up in Wyoming after the 29th, so you could set it up before then.
Before the 29th of July, let's set up for a settlement conference, please, Mr. Carrion. Thank you. Okay, anything else, Mr. Norris, Mr. Avila?
No, nothing from the defense, Your Honor. Thank you.
Okay, Mr. Avila?
Nothing from me, Your Honor.
Good. Okay, Mr. Orozco, thank you. Good luck to you, sir. We're not going to see you again until we're going to plea you or until your case is disposed of, right?
Thank you. Yes, ma'am.
Thank you, sir. You all may be excused. Have a great day.
Thank you.
Thank you, Your Honor.
Thank you. Thank you, Mr. Norris. You may have a great day. Ms. Williams, thank you so much for being here. I really appreciate you. I understand how and why the ball was dropped, so no worries.
Yes, I apologize. Thank you, Judge. Have a good
Thank you. Have a great day. Thank you.